Let me thank all of you who are here, who have given up your time tonight to come and hear very concerning topics that are sweeping our country and, of course, sweeping universities across our nation. We are honored, first of all, to have in our midst who will be formally introduced at a later time. But we do have three of our outstanding judges in the audience, and if they would just stand, and they will be formally introduced at a later time. Judges, if you would just stand, we'll give them a round of applause. My name is David Griffin, and I am the chair of the Dorothy L. Thompson Civil Rights Lecture Series Committee, and it is my distinct honor to welcome you here tonight. Before I introduce to you our interim provost, Dr. Ruth Dyer, who will introduce our panel members and our moderator, I would like for the members of the Dorothy L. Thompson Civil Rights Lecture Series Board, if you would stand where you are and be recognized. This board has worked diligently for the last several months to bring a topic to this campus that we think is a dying concern on many of our minds. At this time, I would like to ask our interim provost, Dr. Ruth Dyer, if she would come to the podium and introduce the two experts in this area. Let's give her a round of applause.
Well, good evening. I am delighted to see such a wonderful crowd at this event. The topic that we have, I think, is going to be very stimulating, and I'm certainly looking forward to the dialogue that we're going to have here tonight. I want to give you a little bit of background about this lecture series, and the Provost's office actually established this Civil Rights Lecture Series in 1994 in recognition of Dorothy Thompson's contributions to the field of human rights on campuses throughout Kansas and the nation. Ms. Thompson was the director of the Office of Affirmative Action from 1972 until 1985, when she became the Associate University Attorney. Ms. Thompson served in that office until her untimely death in 1992. Dorothy was a role model for women and attorneys in Kansas. She was highly regarded by persons of all political leanings for her diplomacy, judiciousness, and effectiveness. Dorothy Thompson had an abiding respect for all people and a profound commitment to fairness and equity. A civil rights lecture is a particularly fitting memorial for her. Following the 2008 landmark U.S. Supreme Court case of District of Columbia versus Heller, many critical questions remain to be decided. These questions include whether or not this newly recognized personal constitutional right even applies to the states under the 14th Amendment. Two legal experts on Second Amendment law, Professor Bill Merkel of Washburn Law School and Professor Ray Diamond of Louisiana State University, will hold a dialogue, lead a discussion, and debate these unanswered questions about your constitutional right to possess weapons in your personal lives and for purposes unrelated to military service. Professor Ray Diamond from the Louisiana State University Paul M. Hebert Law Center is a 1973 graduate of Yale College and a 1977 Yale Law School graduate. He has an extensive list of accomplishments in the academic as well as the public and private sectors, and a long list of publications. He has written important articles on the Second Amendment, school desegregation, affirmative action, diversity, civil rights, and antitrust law. In 1999, Professor Diamond was awarded the Harlan B. Carter George S. Knight Freedom Fund Award by the Civil Rights Defense Fund of the National Rifle Association for his publications on the Second Amendment. And in 2003, he was one of 3 authors awarded the David J. Langham Senior Prize for Historical Literature, honoring Brown versus the Board of Education, Caste, Culture, and the Constitution. This was the best book in the legal history and legal biography category. Professor Diamond teaches antitrust law, criminal law, constitutional law, legal history, and race relations and the Constitution. He is a member of both the Louisiana and the District of Columbia bars. Professor Diamond's insights on race relations and the right to bear arms and his analysis of the Supreme Court's decisions in the Heller case will be the basis for his presentation tonight. Presenting a legal perspective on constitutional interpretation will be Professor William Merkel of the Washburn University School of Law. Following graduation from Johns Hopkins with a bachelor's in history, Professor Merkel worked as an analyst with the Department of Transportation in Washington, D.C. before turning to graduate studies. He completed his Juris Doctorate at Columbia Law School in 1996 and then worked in appellate litigation with the firm of Wiley, Rhine, and Fielding in Washington, D.C. He is the author with the late Richard Uveler, I'm sorry if I didn't pronounce that correct, of The Militia and the Right to Arms, or How the Second Amendment Fell Silent. He taught American history at Oxford University and comparative introduction to American law to foreign-trained LLM students at Columbia. Professor Merkel received a doctorate in history from Oxford University in 2007. He is working on a manuscript for a book to be titled Jefferson and Slavery, A Legal History. Professor Merkel is a member of the New York and District of Columbia bars. Our moderator tonight is Professor Michael Kaye of Washburn Law School, where he teaches evidence law, trial advocacy, and criminal procedure. Professor Kaye directs the Washburn Law School Center for Excellence in Advocacy. He is a former director of the Washburn Law Clinic. Professor Kaye's research interests include law and psychology, and he has co-authored articles based on attitudinal surveys of judges and lawyers, as well as studies concerning psychological dimensions of Fourth Amendment law. He is a regular contributor of articles for the American Bar Association publication previews of United States Supreme Court cases. Professor Kaye is currently a member of the Kansas Criminal Law Recodification Commission and the Kansas Judicial Council Death Penalty Advisory Committee. Professor Kaye is a graduate of Cleveland Marshall Law School of Cleveland State University and holds an LLM in international law from New York University Law School. Professor Kaye is a member of the California and Kansas bars. Before I turn the floor over to our presenters, I would also like to recognize and welcome the panel of judges who will be from the Kansas Court of Appeals, who will be hearing the Court of Appeals docket tomorrow right here in Forum Hall. This is a once-a-year opportunity for you to experience the judicial process right here on our campus. So please welcome again the Honorable Melissa Taylor Standridge, the Honorable Henry W. Green, and the Honorable Richard Green. The judges have graciously agreed to answer questions relating to today's program during the question and answer period. So I invite you to enjoy this program. Professor Kaye, the floor is yours.
Shall we take our seats up here, Judge? Well, thank you very much, Provost. This is indeed an honor for me to be here tonight at a time when there could be no more important issue than the recent Supreme Court decision of District of Columbia versus Heller, which came down only last year and has left us in a situation in which many of us have questions as to how it affects our rights in our everyday life. The Dorothy Thompson Lecture Series has always tried to relate civil liberties issues to the community here, the academic community and the community around ourselves and the state of Kansas also. And so I'm very pleased to be here to participate in it, especially with the judges. I'd like to say one thing before I start, though. We've stood up, our group stood up, the Dorothy Thompson committee, the judges stood up. Well, we've got some Washburn University law students who came all the way here for this debate. And in the classes that I teach, everybody has to stand up when they talk. Now, we won't enforce that tonight on our guests, but how about it? If you're from the Washburn Law School, would you stand up so everybody can see you? We're very proud of them, and we're proud of our school. You know, debate is a part of the fabric and the history of the United States. We know about constitutional debates. We teach children and high school students and college students to argue. We train lawyers by training them to argue. We watch debate on television. We watch argument. It's hard to imagine democracy without debate. And what debate means for us here tonight is our opportunity to sharpen our own ideas, to sharpen our arguments, and to achieve some clarity in issues that matter to us. And so I'm very, very pleased also that our discussion will begin through a debate, and you'll be able to participate in it also. You'll be able to ask questions of our panelists. Now, here's how we're going to do it. That each side will have an opportunity to make a 14-minute opening statement. Our first presenter will be Ray Diamond. He will have 14 minutes to explain to you why he believes there's an individual right to bear arms and what that should mean to us. Following his presentation, Professor Merkel will have 4 minutes to question him or challenge him if he wishes on what he has told us tonight. After that, Professor Merkel will make an opening. 14 minutes are allotted to him, and Professor Diamond will have 4 minutes to challenge or examine Professor Merkel, on what he has said. After that, I'm going to ask the judges if they have questions. I only differ with the provost in one small respect. Judges don't have answers. Those of us who read their opinions sometimes think, well, maybe they should give us some more answers. But basically, judges don't tell us what they think as often as they ask us what we think. And we're going to ask the judges, if they wish, to question the debaters on something they have said. And I also want to mention something else that's of great importance, which is that these judges tomorrow will be hearing a case at 1 o'clock in the afternoon here in this room that raises a challenge to a criminal conviction on Second Amendment grounds. So in other words, after you and they have heard this talk and participated in it, you can come back tomorrow for the most unusual and exhilarating experience of seeing it actually being tried out in argument here on this campus. It's remarkable. It almost doesn't happen. And we're fortunate that it happened, and we're also fortunate that the judges went to a lot of trouble to make sure that if there was such a case, you would hear it. So keep in mind that tomorrow at 1 o'clock, this would be the place to be. After the judges have asked their questions, we are going to we're going to have questions from the audience. Now, the way we're going to do that, we have, with the people who are going to be passing out and collecting the cards, please raise a hand so we can know where you are. Are they here yet? Here's one, okay. And we have another one. I don't think you can see their hands. Are you going to be standing in the corner over here on the side? So the people, okay. If you will go to the side during the talk, or right after, people who want to ask questions will be given cards. You can write your questions on them, and I will ask those questions of the judges, of the panelists. And then, after that is over, both debaters will have 3 minutes to make closing statements. And after that, we'll have cookies, which are outside. And so, I will keep them to their to the time limits, and I hope that you enjoy this. I think you will. So let's begin the debate.
I want to thank your provost, Dr. Dyer, very much for that kind introduction, and I want to thank the organizing committee for inviting me to participate in the Dorothy L. Thompson Civil Rights Lecture Series. We're here today to do two things. One of those is to celebrate Constitution Day. The second is, of course, to recognize Ms. Thompson's contributions to the cause of diversity. Her biography shows that she was a lawyer who not only was here to do well, but also to do good. And she stands as a worthy role model to many of us. We are to do this through the guise of what is styled and organized as a debate on the subject of guns on campus, the new understanding of the right to bear arms. For reasons that I hope my remarks will make clear, I intend to address only indirectly the question of guns on campus, and I intend to address primarily and directly the subject of the new understanding of the right to bear arms. The Second Amendment debate is part of the larger gun control debate and has been an inescapable feature of American life for 2 generations. An integral part of the often acrimonious national debate over gun control, the Second Amendment itself reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." This provision has been subjected to 2 instrumental interpretations by partisans of the gun control debate. Proponents of stricter gun controls have stressed the amendment's first clause, arguing that the Second Amendment was designed to protect the right of states to maintain militias free from potential encroachment by the new Congress's power to organize, arm, and discipline the militia. Let's call this the collective rights view. Opponents of stricter gun controls, advocates of the individual rights view, have argued exactly the opposite. They stress the provision's second clause, arguing that the mention of a well-regulated militia should be viewed as an amplifying rather than a qualifying clause, that maintaining a militia of the whole citizenry, armed with privately owned weapons, was but one reason for securing the people's right to arms, that the amendment was also designed to secure the citizens' right to arms for private as well as public purposes. This debate between collective and individual rights theorists has been resolved. In June of 2008, the Supreme Court, by a 5-4 majority, issued a landmark opinion written by Justice Scalia in District of Columbia versus Heller. This case determined that the right to keep and bear arms is an individual right that rendered unconstitutional federal legislation that effectively banned handgun possession for purposes of self-defense in the home. Actually, a rather limited decision in some respects. The debate between those who favor gun control and those who oppose it moves then to new territory not resolved by Heller. What exactly is the extent of the right? Under what standard will putative violations of the right be measured? Is the right fundamental? Is it incorporated and thus enforceable against the state governments by the 14th Amendment? Cases parsing these questions are underway even as we speak. Let me state clearly that Heller was correctly decided. Indeed, I will go so far as to say that there is little that is new in Heller's understanding of the right to keep and bear arms. The Heller opinion's reasoning confirms something of the reasoning of U.S. versus Miller, the 1939 case that constitutes the Supreme Court's preceding foray into Second Amendment jurisprudence. Miller protected the right to keep arms useful for militia service, not in the select militia. The select militia of today is our National Guard, but instead useful for service in the militia of the whole, constituted by citizens armed and this is important, with their own weapons. But a policy discussion of the right to keep and bear arms should not end there. For the individual rights perspective confirmed by Heller raises fascinating questions concerning public participation in community and national security, societal and technological change and original intent, individual self-protection and public safety, and of course, the wisdom of permitting the state a monopoly of arms. So what I would like to do in today's discussion as it proceeds is both to support the notion that the Heller case was correctly decided, and to issue a challenge to extend the firearm policy debate beyond the minimization of the detriment arising from our status as an armed society, but to the maximization of the benefit to be realized from that same status. Any discussion of the Second Amendment should begin with the repetition of the observation that the framers of the Bill of Rights did not believe they were creating new rights. Instead, they were simply attempting to recognize rights already believed to be part of the English constitutional heritage. An analysis of the Second Amendment should thus begin with the framers' world and their perception of the right and duty to bear arms as part of the traditional rights of Englishmen. The English settlers who began to populate North America in the 17th century were heirs to a tradition over 5 centuries old governing both the right and duty to be armed. At English law, the idea of an armed citizenry responsible for the security of the community had long coexisted with regulation of the ownership of arms, particularly along class lines. Traditionally, all able-bodied men were considered part of the militia and required to furnish their own arms while performing militia duties. In addition, all citizens were subject to service in the posse comitatus. That tradition was strengthened and transformed into a right by the religious and political turmoil of the 17th century. The attempt by Kings Charles II and James II to disarm large portions of the Protestant population led to a provision in the English Declaration of Rights of 1689, protecting the right of Protestants to own arms. English law recognized a right and a duty to bear arms, but it was a right and a duty highly qualified by class and religious distinctions. Those qualifications would be altered by the American colonial experience, an experience that led to a consensus that the entire population, or at least the entire white population, needed to be armed and deputized to ensure community security. The need for racial control was one that broadened the right to bear arms in the American context. English law had qualified the right to possess arms by class and religion. American law was less concerned with such distinctions. All whites were expected to possess and bear arms in defense of their commonwealths, both from external threats and from the internal ones posed by Negroes and Indians. In most colonies, all white men between 16 and 60 were part of the militia and required to be armed. They were expected to perform traditional militia and posse duties and were required to act as slave patrollers in those colonies with large slave populations. The need to deputize the white population extended the right to possess arms to classes traditionally viewed with suspicion in England. This right even went so far as to include indentured servants. The colonial experience helped to strengthen the appreciation of early Americans for the merits of an armed citizenry. That appreciation was strengthened yet further by the experience of the American Revolution. If necessity forced the early colonists to arm, The Revolution and the preceding friction with British regulars served to revitalize Whiggish notions that standing armies were dangerous to liberty, and that militias, composed of the whole of the people, best protected both liberty and security. These notions found their way into the debates over the Constitution. The militia clause excited fears among those who believed that the new Constitution could be used to destroy both state power and individual rights. Many feared that the clause could be used by Congress to do away with the state's control over the militia and to disarm the population. Hamilton and Madison, in the Federalist, sought to reassure critics who feared that the new Constitution would destroy both the independence of the militia and the right to keep and bear arms. The record is clear that both Hamilton, who was highly skeptical concerning the military value of the militia of the whole, and Madison, who was a strong supporter of the idea of an armed population, deterred tyranny. That both of them saw the Constitution as intended to keep an armed population as a component of the militia. Indeed, Americans who commented on the right to bear arms, from St. George Tucker to Justice Story to Chief Justice Taney in the Dred Scott case, these commentators essentially agreed with Lord Blackstone. For Americans, Blackstone was the primary source of English common law. They agreed with Blackstone, who saw the right essentially as being among those fundamental rights without which the rights to life and personal security and property would be insecure. The relationship between the right to arms and the protection of life, liberty, and property was of great concern to the Republicans after the Civil War and emancipation. The black codes passed in southern states sought to preserve much of the antebellum social order. These codes included severe firearms restrictions for the black population. The efforts to disarm the freedmen particularly worried many Republicans who feared that the one group of presumable and proven Southern Unionists would be disarmed while disloyal whites would remain armed. And so some of the major evidence that the 39th Congress intended to protect the rights in the Bill of Rights from action by the states can be seen with respect to their remarks about the Second Amendment and Southern measures designed to disarm blacks. The evidence is clear that the 39th Congress regarded the right to bear arms as an individual one and a fundamental one, and that they meant for that right to be applied to the states, particularly the southern ones where the right was being denied to blacks. Thus, I say confidently that if the Second Amendment right was not considered an individual right by the framers of the Second and later the 14th Amendment, and by Americans who interpreted these amendments, it is the best kept secret of the 18th and 19th centuries. After the enactment of the 14th Amendment, the Supreme Court had occasion to pronounce on the relationship between the Second and the 14th Amendments in two cases, United States versus Cruikshank and Presser versus Illinois, in 1876 and 1886, respectively. In each case, the court's view that the 14th Amendment did not enhance the power of the federal government to protect constitutional rights against private and state infringement. In other words, the Second Amendment was not to be incorporated against the states. This view helped weaken both amendments, both the Second Amendment right and the 14th Amendment right to due process. Indeed, an examination of this record suggests that a good deal of the court's decision-making that weakened the effectiveness of the Second Amendment in the Presser and Cruikshank cases was part of the court's overall process of eviscerating the 14th Amendment, a process that came to fruition with Plessy versus Ferguson in 1896. The stage is therefore set for judicial consideration of whether the right to keep and bear arms is a fundamental one, as I conclude that it is, and as the framers of the 14th Amendment thought, and as Justice Scalia hints in Heller, and whether Presser and Cruikshank should be overruled. But whether or not these cases are overruled, consider this. Much of the contemporary crime that concerns Americans is in poor and urban and oftentimes black neighborhoods, and a case can be made that greater firearms restrictions might alleviate this tragedy. I expect Professor Merkel to make this argument. But another, and I would argue stronger case can be made that a society that has a dismal record in protecting a people has a dubious claim on the right to disarm them. Perhaps a re-examination of this history of the Second Amendment can lead us to a modern realization of what the framers of the Second Amendment certainly understood, that it is unwise to place the means of protection totally in the hands of the state, and that self-defense is also a civil right.
I'll give you the same amount of time. I'll do it if you want.
What am I supposed to do now?
Question. You've got 4 minutes to question.
A 4-minute long question?
No, he's going to answer some of the questions that you're asking. That's what we discussed. All right, Professor Merkel now has 4 minutes to question Professor Diamond on what he has just told us.
Just to be clear, our dialogue will take 4 minutes.
Yes.
I think the fundamental question that is on many people's minds, and probably to some degree on Ray's mind and my mind this evening, is what policy options are available, what policy options are optimal to minimize violence in the United States, to minimize the threat of violence experienced by individuals. You may say to yourself, I feel threatened by violent persons, and I choose to defend myself with privately held weapons because I don't trust the police to do the job for me. The provosts at a particular university, the governing body at a particular university, and bear in mind, constitutionally speaking, we're really only talking about, at least under the terms of the Heller decision, federal universities, of which there are none, except arguably the University of the District of Columbia in a federal enclave. But with Professor Diamond, I expect the Second Amendment right announced in Heller to be incorporated, which is to say that the court will soon hold that the right applies to limit the ability of the states to restrict Second Amendment freedoms as well. So ultimately, we'll be talking about state universities as well. But I want you all to be aware that constitutional restraints on policymaking don't apply to private actors. So, the text of the Constitution has no bearing on whether Harvard or Yale choose to ban guns on campus. We're talking about guns at public
You're
institutions
going to
here.
have to ask him some questions.
Yeah,
You've only got 2 minutes left.
well, I'll yield my time.
Okay. You then are free to begin.
Well, let me ask the question I was hoping to ask. I'll take back my time. The question is, why do the good people of the District of Columbia not have the policy option to ban guns? We've been chatting about this all day. I think it's an important question, right? In about 1974, the District of Columbia decides, look, we have the highest murder rate in the country, we're going to ban guns, make it virtually impossible to hold guns. Your answer so far is the black majority government in the District of Columbia, after Home Rule, can't prohibit weapons because people in the 1780s, people in the 1860s, white people in government allegedly didn't believe in a governmental power to infringe on the private right to arms. So what's illegitimate about the district's choice that was struck down in Heller?
What's illegitimate about the district's choice in Heller is that it infringes, as Justice Scalia said, on a very basic right of self-defense. This right of self-defense is included in the Due Process Clause. This right of self-defense is imported into our Second Amendment jurisprudence. Now, let us be clear that Justice Scalia's opinion was drawn very narrowly. He spoke in terms of legislation that had the effect of outlawing the use of handguns, which he recognized were primarily looked to by the civilian population for individual self-defense, and that the legislation had the effect of banning the use of such firearms in the home. And his holding is limited to that. Now, Justice Scalia hints to us very broadly that there are all sorts of time, place, and manner regulations that can be undertaken by the federal government. He says that the keeping or possession of guns in schools or in governmental buildings, he has no reason to think that such regulations would be unconstitutional. So what I believe is that the District of Columbia has a great many options available to it in the way of regulation that do not go so far as to ban the right to keep arms in the home. Now, and that's all that Justice Scalia said. We still have many cases before we can parse out exactly what the right under the Second Amendment really entails.
Okay, thank you very much. Professor Merkel, you have 14 minutes.
But what Justice Scalia did, at a bare minimum, in Heller, is intervene to veto, on behalf of a one-vote majority on the 9-person Supreme Court, a legislative solution that the democratically elected legislature in the newly empowered Home Rule District of Columbia in the early 1970s, newly escaped from nearly 200 rules of colonial administration at the hands of a nearly lily-white Congress, embraced with a view to reducing the astronomical crime rates in the District of Columbia. Now, one standard that law courts frequently use in engaging in judicial review, as they call it in the United States, but let's be honest, it is veto of legislation by democratically enacted legislatures, is the claim that the legislation in question was wholly irrational. There was some dispute in the Heller decision about what standard of review the court was actually applying. Justice Scalia wanted to apply, he made clear in oral argument, the most strict, demanding standard of review the court ever uses. It's called strict scrutiny. And until very recently, there was an aphorism on the streets among the constitutionally cognizant that strict scrutiny was strict in theory, but fatal in fact. It basically meant that the court was going to come up with a reason for vetoing legislation as soon as you saw the words strict scrutiny in a judicial opinion. Justice Scalia couldn't get 5 votes on board for strict scrutiny. It's unclear what standard he used in Heller, but he makes the claim that the D.C. regulation, the D.C. gun laws, would have been invalid under any standard of review, including rational basis review. And when the court engages in rational basis review, what it does is veto legislation by the democratically enacted legislature, whether in the district, a state, or on the national level. And bear in mind, this is veto of democratically enacted legislation by 9 unelected, lifetime, unaccountable, appointees. I love the judiciary. I don't mean to criticize our learned and distinguished guests for being unelected or appointed. Actually, I don't know whether you're unelected in Kansas. You may well be elected, which is, well, there was a movement, I think, to elect trial court judges, but very few elected appellate judges at this stage in American history. But in any case, the members of the judiciary are not directly accountable to the people, right? So it's an interesting question when persons not directly accountable to the people decide that legislation must give way. There is no possible claim that the legislation in the District of Columbia was utterly irrational, because the homicide rate in the district has fallen since the strict gun control laws were instituted. It didn't fall immediately. There was a time lag, but we've gone from over 600 murders a year in the district to just over 200 murders a year. We've seen a proportionately similar decline in New York City since the embrace of a strict gun control regime. Now, proponents of the wide distribution of arms claim, with the famous, although controversial, sociologist John Lott, more guns means less crime. Look, there are more guns about, criminals are going to be intimidated. You're not likely to mug someone if you have reason to believe that 90% of the people on the streets are armed. And there's obviously some intuitive truth to this. When I was a young punk living in England, interested in street fighting, I would resort to street fighting frequently because I knew I could outrun anyone with a knife. When I moved back to New York City, I gave up on street fighting because I knew, number one, there were a lot of people in New York City who were badder than I was. I was getting older and less psychotic. But also, I knew that there were people on the streets of New York City who were armed. This deterrent effect does have some logic, but it's a bit rich for a law court to say the democratically elected representatives in a particular constituency cannot choose the arms control option or cannot choose a strict gun control option. To be sure, to this day, the District of Columbia and Chicago, which have the strictest gun control laws in the country, have quite high murder rates by U.S. standards. New York City, on the other hand, has a quite low murder rate. And if you expand the frame of reference and look at arms distribution around the world, it's interesting that two of the advanced industrial societies with the lowest homicide rates, Japan and the United Kingdom, have very few guns at all, and two other advanced industrial societies with quite low homicide rates, lower than that of the US, France and Germany, have lots of guns, but gun ownership is tightly regulated. So my point is, why shouldn't this policy option be available in New York City or Washington, D.C., or San Francisco if the people of those jurisdictions choose this policy option? I'm not saying gun-grabbing liberals from back east should come out to Kansas and take away your guns. Right? This is a very different claim. The claim is, what is the right of an officious intermeddler from Montana to go to the District of Columbia and say, I'm going to file a lawsuit and see if I can get a one-vote majority in a court of appeals to overturn the policy option that your democratically elected legislature has chosen. Because I believe in guns and I want to project my perceived right to gun ownership all across the country. I want to take certain policy options off the table. Now, when Justice Scalia, how much time do I have?
You have about 8 minutes left.
Great. So when Justice Scalia makes this policy choice on behalf of the District of Columbia and says, good people of the district, one option you don't have is airtight gun control. One option you don't have is a regime of gun control that is so strict that it's difficult for a person in his own home when he hears sounds that signal an intruder at the door or at a window to grab a gun, get a gun ready, and gun down the intruder, right? The laws in the district allowed keeping guns in the home, but they had to be locked up, they had to be disassembled. Access to the gun was not immediate. There wasn't, in the minds of Justice Scalia and several other justices on the court during oral argument made clear this was important to them, a real ability to defend yourself. So great. Is there a constitutional right to self-defense? Why not? Why shouldn't we have a constitutional right to self-defense? Well, I have no argument that we shouldn't have a constitutional right to self-defense. My claim is that the text of the Second Amendment has absolutely nothing to do with purely private self-defense. Recall, the text reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." It doesn't read ready access to tasty game being a lovely way to supplement your diet. Citizens should be free to hunt with weapons. It doesn't read the danger of street crime and home invasion being a serious concern. The good people of this country should be free to arm themselves in the home to defend against invaders. It talks about a militia-related right. So what did this right mean at the time it was originally committed to the constitutional text, and why should we care what it meant then? Two very different questions. Justice Scalia doesn't answer the second question. He answers the first question, and his answer is preposterous. It is absurd. It makes no sense whatsoever. In fact, I will go on record to say that it is disingenuous. It is false. 12 members of the House of Representatives spoke about the meaning of the Second Amendment when it was under consideration in 1789. All of you good citizens and visitors from foreign parts, you can easily access this text at the American Memory Project of the Library of Congress, Annals of Congress, Series 1, 1789. The debates take place on the text that became the Second Amendment on August 17th and resume on about 10 pages later in the record on August 21st. About four pages of reading, easily done. If you're going to talk about the original meaning of the Second Amendment, please at least read the debates in the first Congress. 12 members spoke. Not one of them said anything about home defense. Not one of them said anything about defense against armed intruders. Not one of them said anything about muggings on the streets. They all spoke about the danger of standing armies, which is to say large military establishments, expensive armies that provide a ready temptation for a glory-seeking chief executive to engage in foreign military adventures that are expensive, that require deficit spending to keep up, that require foreign borrowing, that tempt contractors into relationships with the government, that compromise the integrity of legislators and Treasury officials. Exactly the scenario described by President Eisenhower when he discussed the military-industrial complex in his farewell address. I would argue exactly the scenario we confront today. That's what the framers of the Second Amendment were discussing in the first Congress. Not one said a thing about defense against burglars. In this day and age of electronic databases, it is relatively easy to do the work yourself. There are several databases that I commend to your attention. Charles Evans' American Bibliography is available online. The Early American Newspapers series is available online. Between 1690 and 1800, there are about 400 surviving uses of the phrase bear arms in the documentary record of surviving books, pamphlets, and newspapers published in 18th century America. Over 95% of these surviving uses relate to militia service or military duty. Most of the uses related to carrying weapons for private purposes are clearly written by the semi-literate and the eccentric. So what Justice Scalia does in the Heller decision is he says, the historical record is clear. Bearing arms meant in 1791, when the Second Amendment was ratified, quote, carrying weapons for purposes of confrontation. That is bunk. It meant no such thing. Over 95% of the surviving uses of the term referred to rendering military service or doing militia duty. Does that mean we shouldn't have a right to home defense today? No, it has nothing to do with it. I readily concede we may have a Ninth Amendment right, we may have a substantive due process right, the right may be built into the criminal law. Right? Nobody, to my knowledge, has been rightfully convicted of homicide or assault for using violence, using deadly force in self-defense. Right? It's part of the criminal law. Someone attacks you, you may use violence to resist that attack as long as the violence is proportionate, as long as you're under threat. So, should we have a right to arms for private purposes? Do we have a right to arms for private purposes? Probably, because most Americans want it. Does it have anything to do with the original meaning of the Second Amendment? No. So why are we engaging in this historical conversation? Why are we engaging in myth-making? Why are we basing our discussions today about whether we have certain rights or should have certain rights on historical fiction? God only knows. It makes no sense to me. If you believe in arms possession, great, but make the defense, make the argument on grounds other than historical fantasy. Why engage in historical fantasy? How does it prop up the argument? At least read the documentary record before you assert what the framers meant, what the framers believed. Let's be honest. There's a lot to be said for honesty.
Thank you, Professor Merkel. You know I have 4 minutes to pose questions to Professor Merkel.
Well, Bill, I have two questions for you. The first one concerns Marbury versus Madison, which those of us who have studied constitutional law know established the concept of judicial review in the first 2 decades of the 19th century. And my question is simply this. What place does Marbury have in your jurisprudence? What place does judicial review have in your jurisprudence? Is there any place for judicial review in your jurisprudence? Isn't every act of the judiciary a usurpation of a legislative prerogative?
Great question, Professor Diamond. Thank you. On one level, yes. That's why I think the burden is on the law courts to explain their behavior when they strike down legislation. You described to me earlier today something of a, you might, I don't mean to put words in your mouth, but a conversion experience. You were once pro-gun control and you rethought the problem, arrived at some new insights. Your life experience convinced you that the problem required rethinking, and you eventually came round to the view that there should be a robust private right to weapons. Likewise, I am a product of the received wisdom that judicial review is the American way. It's the great American contribution to political science. Nobody disputes that Marbury versus Madison represented the first instance of a law court striking down legislation on the national level in any country, and eventually after World War II, judicial review ceased to be an American eccentricity. It was embraced around the world. But I think the burden still rests on the courts to explain why it's legitimate. Marshall's claim in Marbury versus Madison, I think, no longer holds today. He made a very interesting claim that the legislature is only the people's agents. The Constitution is the voice of the people themselves. If you hire an agent to do a job for you, and the agent does something you did not authorize the agent to do, it's what's called ultra vires, it's beyond the authorization, it's illegitimate. In 1803, in Marbury versus Madison, Marshall says that's what Congress did with Section 13 of the Judiciary Act of 1789. They acted without authorization, and Marshall says we, the Supreme Court, aren't vetoing their legislation. We're just pointing out that they went beyond the people's authorization. The text of the Constitution authorizes Congress to exercise certain powers. They've done more than that here. But can we make that claim today when those who voted to ratify the Constitution are long since dead? And Jefferson pointed out, based on demographic data available to him at the time, that the average lifespan of a generation of adults who vote to approve a Constitution is 19 years. In other words, after 19 years, half the people who voted to approve any particular Constitution are gone. So today, when the Supreme Court strikes down legislation on behalf of the people who ratified this constitutional text, they're striking down legislation on behalf of 500,000 long since dead people who voted to ratify this text in a nation of 4 million people that covered less than half the territory of the United States today, that now embraces over 300 million people, whose democratically elected legislature in Washington, in the instance of judicial review of federal statutes, voted to enact law based on our living authorization to them. So I think judicial review on an instrumental level has a pretty decent record, particularly in the post-Brown versus Board of Education era. Judges have prevented legislatures from oppressing people. But what is it that gives us faith that judges will always be better than legislatures in avoiding the oppression of people, avoiding rights violations, particularly when we can always vote the legislature out of office, and at least on the federal level, we can't vote the judges out of office.
Do you have another question?
Well, I did, but
Well,
my time has run out.
I'll extend it.
Very good.
Susan, questions are
Well,
interesting.
my second question is this. What place does Blackstone's statement that the right to arms is essential to the protection of life, personal security, and property, what place does Blackstone's statement have in your jurisprudence, your understanding of the original meaning of the Second Amendment?
I'm going to ask you to limit your answer to 2 minutes.
No problem. No effect on my reading of the Second Amendment. It may have a great deal to do with the original understanding of the Ninth Amendment, of rights inherent in due process or fair process. Might have a great deal to do with the original reading of the body of criminal law. In other words, a right against prosecution for using force in self-defense, but not necessarily rooted in the text of the Second Amendment. After all, Blackstone, number one, was dead by the time the Second Amendment was proposed, so he didn't know the text. He wasn't analyzing that text. Number two, he was no friend of American liberties anyway. Right? As a member of Parliament, he voted to use the most vigorous means to suppress the American Revolution. And number three, Blackstone was a creature of time and place. Right? Blackstone had to explain that revolution against the government of George III was illegitimate, but that George III's government was legitimate, even though it was an heir of the government of William and Mary that came to power by revolution. So when Blackstone talks about revolution, he does a wonderful balancing act. And the more you read Blackstone on revolution, you come to realize that there's only one revolution that was justified in Blackstone's eyes, and that's the one that put his government into power in 1688, 1689. So the test for valid revolution is, did it take place in England in 1688, 89?
I think your time is up. Thank you very much. Well, we've reached the point now where if the judges wish to ask questions of either of the debaters, we will welcome them. The debaters are going to be limited strictly to 3 minutes in response per person.
2 quick questions, and I'll try to be brief, and I know my colleagues have a question or two as well. First of all, to Professor Merkel. Let's assume hypothetically that I find your position on original construction and going back to the historic documents quite compelling, making us all wonder how Justice Scalia got where he got. Why would you contaminate that argument with what I would have to characterize as unorthodox views on judicial review in Marbury versus Madison? Is that critical to your arguments as to original intent? Because to an appellate judge, it's, I wouldn't say offensive, but it doesn't go down well.
I was shocked into my current position on original view, on the legitimacy of judicial review by reading Jeremy Waldron's article in the 2005 Yale Law Review. When I first read it, I said, this is blasphemy. Like, this is unorthodox. I'm an American patriot. Shut up, you New Zealander. Go back to Cambridge. I'm going to ram American-style judicial review down your throat. But after 3 years of thinking about Waldron's point, I can't come up with a satisfactory answer. What is it about judges that makes them better rights protectors than legislators? I don't know.
And that might be a good subject for another time. But my question is, does your argument as to Scalia's failings, is it hinged on that?
No, you can pretend I'm not crazy, and I never said anything that I said about judicial review. In fact, everything I've written so far on the Second Amendment, I wrote, well, until my last article, without reference to my now, unorthodox views of judicial review. So you can cite anything I wrote before 2007 without looking like you're citing a crazy man.
And just to clarify, in Kansas, appellate judges are accountable to the people in the sense that every 4 years we're subject to a retention election after public evaluation. And so last fall, 1.1 million Kansans voted whether or not to retain individual appellate judges, just so you know.
Well, congratulations to the
Kansas.
three of you, and to the good people of Kansas.
A question for Professor Diamond now. From the text of Heller, from the majority opinion, we find Justice Scalia said, nothing in our opinion should be taken to cast doubt on longstanding prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. Footnote, this is not intended to be an exhaustive list. You referenced this briefly in your remarks. Do you view that as an essential holding of this case or mere dicta with respect to whether or not this is an absolute right?
I think when the Supreme Court speaks, there is no such thing as mere dicta. I think Justice Scalia is broadly hinting at us that this court is not ready to engage in strict scrutiny. He wasn't able to get that majority. It's not willing to engage in strict scrutiny with respect to these time, place, and manner regulations. And I suspect very strongly that we should look for the federal courts, to the extent that they are reviewing federal gun control, and if incorporation comes about, state gun control. I think we should not look for the courts to strike down much, if any, of this time, place, and manner regulation. And my basis for saying that is not simply that from a political perspective, courts would not be well advised to do that. It is also that in states where there is a very strong individual right to arms in state constitutions, state judiciaries have not had any trouble upholding those same sorts of regulations. So as far as the question of what about guns on university campuses, I would not expect that such a limitation would be unconstitutional. And of course, the reason, if you want to think about this, college campuses are full of young people under the age of 26. People, in fact, scientists tell us, whose brains have not fully developed such that they have the judgment that adults have. Young people who do a lot of drinking, and young people who sometimes, and I used to be young, I can say this, do crazy things. Unlike Professor Merkel, by the way, I did not pick any fights in England or any place else because I am not fast enough to run from anybody. But I think that these sorts of considerations suggest that under almost any standard, a regulation limiting guns on university campuses would not be unconstitutional.
Thank you, Your Honor. Judge Standage?
At the risk of subjecting myself to ridicule, I'm going to say that Judge Green kind of stole my question. But taking that one step further, you know, where would you draw the line if you were the court and deciding what regulations were constitutional or unconstitutional? Clearly, you've said in a university setting with individuals 26 and under, then would you expand that to say that you have the right to bear arms if you're 27 years or older, or if you don't have a history of alcoholism, or you don't drink more than one day a week, or where do you draw the line to say what's constitutional and what's not constitutionally limiting your right to bear arms?
You know, there are two ways to answer that question, and one of them is a squirrely way, and that is to take the line of analysis that we take in procedural due process cases. Courts do not determine what process is necessary in terms of fair process. All they determine is whether the process utilized by an agency, whether that particular process meets the due process standard or not. So on one level, it would be rather squirrely of me, and I won't do this, to say I don't want to address that question. What I'll do is I'll address questions about particular sorts of regulations. Now, let me answer in a non-squirrely way, and that is that I have given this question a great deal of thought since I began writing on this particular issue. I think what's necessary, and I think that under previous Second Amendment jurisprudence, this has not been necessary at the federal level. I think what is necessary is a weighing of the political values that underlie the Second Amendment. I, like Justice Scalia, am not prepared to say what the standard of review is, but I am certain that whatever that standard of review is, it would require a weighing of that value against the value of security that surely we hold dear as well. So
Where does it say that in the Second Amendment? That your constitutional right to bear arms is subject to, is subject. I mean, what, I mean, doesn't it doesn't have any limitation, right?
Well, there are very few rights which are not subject to limitation. I suppose if I thought really hard, I could find one or two absolute rights, but there are not very many in the Constitution, if there are any at all. And I don't think that the Second Amendment right is unlimited as well. If you take, for example, the Equal Protection Clause's command that no state shall deny any person equal protection of the laws, the fact is we let states deny people equal protection of the laws. We did it in Korematsu. We did it in Hirabayashi. We allowed racial discrimination under strict scrutiny because we met a test. We do allow discrimination on the basis of gender when it meets a heightened scrutiny test. And we allow any other kind of discrimination when it meets the test of rational basis.
Doesn't that go to Professor Merkel's point that then why should we draw the line at, where we're going to draw the line? Why can't we say because, the statistics show that there's less violence, less murder, if you have these gun regulations, then why can't we, push the line over a little bit more and say, you know what, you can have these regulations because it makes us safer as a society.
Well, I actually think that Bill's comment about the rationality of the District of Columbia regulation, I actually think that that has some legs to it. I think that comment is challenging to me, and I do want to think about it some more. But I think I can offer an answer to his objection, at least in some small measure. It seems to me that there are a great many reasons why crime might have gone down in some of these major cities with very tough gun control regulations. And part of that reason is the spate of mandatory sentences, mandatory and tough sentences at the federal level in the District of Columbia. We have no more parole. We have the Sentencing Commission, which of course is only advisory now, but we have much tougher sentencing today. Maybe the bad guys who are committing all of these crimes are stuck in jail as opposed to being on K Street.
Why we can't move that over is regardless, okay? If we can keep people safer, because my perception is that on one hand, people are saying, the Second Amendment, we have the right to do this. We have the right to defend ourselves, whether it's at the movie theater or whether it's in this room where we are right now. We have the right to conceal and carry and, then you say, okay, but there's going to be limits. How do you decide where those limits are going to be? Clearly, Scalia said there's going to be limits in the sense that you can't bring it into our Supreme Court building, okay? So that's number one limit. You can't bring it into the schools, because these are things that keep people safe. And you even said that even in a university setting, because of different characteristics. I'm saying, why can't we just where do we go on this on this line? How do you determine what's constitutional and not constitutional?
In other words, why not draw the line in the home, which of course Justice Scalia and the majority was unwilling to do. And I think the answer to that, on one level, is a simple answer, and that is because the police are unable to protect us in our homes. The job of the police is not to stop crime, no matter how much we wish it were. The job of the police instead is to catch criminals when they commit crimes in the home. And remember, this is our castle, right? This is where we are to be safe. This is why we have heightened sentences for burglary, because it's an invasion of our domicile. In our homes, we have no place to run to be safe. We don't have company around us like we would in this auditorium or in a movie theater. We don't have people whose presence constitutes a hedge against violence against us. What we have in our home is the potential for Armageddon when the bad guys want to invade our homes. I think that's why Scalia, and he doesn't tell us where else he would draw the line. I think that's why he's unwilling to draw the line in the home. No, I actually am with Scalia on this one. And my friends know how unusual that is a thing for me to say.
I'm going to have to
Thank you very much.
Judge Green, do you have a question?
My question is directed to Professor Diamond. Based upon your historical perspective, I guess my question, where you were indicating that it was greatly understood at the time that the Second Amendment was drafted that whites had the right to bear arms. You said it came from English law. And I guess my question is, if the right was so well understood for whites to bear arms, why did they ever draft the Second Amendment? Because anytime you try to define that particular right, you qualify that right. Mm-hmm. Could you speak maybe on the historical perspective?
Well, there were two arguments offered at the ratifying conventions. One argument was offered that there was no Bill of Rights. Virginia's Constitution had a Bill of Rights, and many of the other constitutions had a Bill of Rights. I think maybe everybody except Rhode Island, which didn't bother to change their constitution until something like 1820. But everybody else had a Bill of Rights, and the objection from the Anti-Federalists was that if there is no statement of rights, that may be a statement that government can do these things that are not allowed. Now, the Federalist argument was that we should not have a Bill of Rights because the statement of rights may be inferred to be a statement that there are no other rights. So I think the Anti-Federalists get the best of that. When they win the argument, we do get a Bill of Rights, and sure enough, as we've seen in the last couple of centuries, it has been constantly argued over time that the statement of these rights is an exclusive statement of rights, that the rights don't go any farther. So I think that's why we have this statement of the Second Amendment. It's a hedge against the fear of the Anti-Federalists that the federal government, the big bad federal government, this strong central government, and we just fought a war against a strong central government that tried to take away our rights. We want a hedge that this central government will never do that to us, at least with respect to these really important things. Oh, and by the way, also those Ninth Amendment rights, those unstated rights that we've never managed to enumerate ever since then.
I'm going to have to stop here because we have a lot of questions coming from the audience. If you'll bring them up, I'll start asking them. We have to be gone from this room at 9 o'clock, am I correct? No? Well, I'm still going to ask them to keep these answers short at this point because a lot of people want to ask questions. All right. All right, so let's see. Okay, here's one from Mr. Diamond. You said it is lawful for the states to put restrictions on people owning guns in their state. By that same token, don't they also have the right to allow people to conceal carry? If the state has afforded that right to 21-year-olds who have taken a class and a background check and had fingerprints taken, how is it lawful for a state school to then deny the same licensed adult that freedom?
You know, that's a question that I pass back and forth with my colleague John Devlin at LSU often, and he's desperately afraid that young people who can get a concealed carry permit with relative ease in Louisiana will be on campuses where they can threaten him. And my answer to that is simply this, that the trust that we repose in the civilian population to carry arms on a concealed basis is a statement about the generality of situations. There may be policy issues which are specific to the university campus, which might be specific to an elementary or middle or high school, such that there are certainly security issues that are specific to courtrooms. As a lawyer, it gives me chills every time I hear that some crazed client or ex-husband of a client has come into a courtroom and killed a lawyer. There are very specific security issues that relate to the sense of disappointment and anger that judicial determinations can visit upon us. And I think that it's those special security issues that allow for the denial of the right to carry on a university campus irrespective of a permit for a concealed carry. I think that that's a legitimate choice for a state to make.
Thank you. Here's one for Professor Merkel. Does not the D.C. gun law suspend or radically limit the individual's ability to defend themselves? Where are their rights in the face of the democratic legislation, democratic in quotes, and if the Constitution does not protect these rights, what does?
Yeah, well, clearly the D.C. gun laws place severe limitations on the ability of citizens and residents to defend themselves in the home against armed attack. I don't think anyone questioned the fact that they did. The D.C. legislature made a policy determination that the people on the whole in the district would be better off with these limitations. Individuals in their homes might be slightly less safe in the sense that they could not repel an invader, but the policy choice that the legislature made was that on the whole, the people would be better off because there would be less armed intruders about, because they would have access to fewer guns, and there would be fewer armed people about on the street. So to me, the question is, and I think it was really the question as understood by all 9 members of the Supreme Court, is this a legitimate policy choice, which is to say, is it a policy choice that's prohibited by the Constitution? Again, I think it may or may not be prohibited by the Constitution, but I think it's fallacious to argue that it's prohibited by the text of the Second Amendment as understood when written in 1791. I think it may very well be protected by the 9th Amendment.
Thank you very much, and this one may relate to that too. Dr. Diamond, Professor Diamond, do you believe that people with criminal records should also have the right to bear arms in their homes and in private areas?
I think it is a legitimate choice on the part of the state to deny people with certain sorts of criminal records the opportunity or the right to keep and bear arms in their own homes. It is so that the Commission of Crimes constitutes that such that society can limit our rights. That's what a punishment is. And the denial of the civil right to arms has traditionally been, both in states and in the federal government, under the federal government, that which disables the right to arms. Now, I have to say something further, that we have domestic violence legislation, both at the federal level and at the states, that disables certain people who have been found to have undertaken domestic violence, either at a civil level or a criminal level. It disables people from keeping and owning firearms. I am personally untroubled with that, and I'm quite confident that that too is constitutional.
Thank you. Here's one for Professor Merkel. If the Second Amendment does not protect an individual's right from state or local policy, then why did the founders write the Second Amendment? Wouldn't the provision dealing with state militias be covered under the 10th Amendment? Can you answer that in 2 minutes?
Yeah. Okay, look. As originally understood, the provisions of the Bill of Rights did not apply against the states at all. They were restraints on federal power. James Madison proposed in the original 12 amendments that he proposed, 10 of which were ratified, an additional amendment that would have limited some state powers with respect to what we now consider First Amendment freedoms. That amendment failed. It wasn't until the 20th century, or to be perfectly correct, 1897, that the Supreme Court, by interpretation, began to apply some of the rights listed in the in the Bill of Rights against the states. So, it's a different question to ask whether the Second Amendment right recognized by the Supreme Court in Heller should be applied against the states from asking whether that right or any other right written into the Bill of Rights was originally considered to apply against state and local government, because originally none of them were considered to apply against state and local governments. Most states, as Professor Diamond illustrated, had their own Bill of Rights in their constitutions. The concern, as Professor Diamond ably pointed out, it was, well, what about this new federal government, this newly created federal government with broad powers described in the Constitution, but not yet constrained by a Bill of Rights when the Constitution was ratified in 1788, which led to the Bill of Rights limiting the authority of the federal government and protecting rights against federal infringement.
We've got one for Dr. Diamond here. Professor, thank you. You're all being called doctor, by the way, so excuse me.
I've gotten a promotion.
Right, that's, I'll stop saying professor. Now, this is sort of like what you've been asked before, but there may be a difference. If you concede that it is acceptable for the government to not allow people to protect themselves with firearms in public, why is it unacceptable for the government to do so in the home if the only difference is that in the home they are also protecting property?
Well, I believe that the home has a special place in English common law jurisprudence as it was translated across the Atlantic. I think we can see this in the early common law of the United States. I think we see it in the criminal laws of the United States. Again, there is something special about the peace and repose that we should expect to have in our homes. We see it in our Constitution. We should be free from invasion by the government, except by reason of a search warrant or otherwise for, if I can, and the judges here know that I'm greatly oversimplifying, or for really, really good cause. We should be secure in our homes, in our persons and in our homes, and we should be secure. And I think that there's, at the risk of repeating myself, a special value there, which renders the home a different environment, and a specially protected environment in which we are the primary protectors of our own lives and our own safety. And I think that that may not be the place in any other environment outside of the home.
I think this is a question for Professor Merkel. Why would you think that the Second Amendment gives a right to people only if they belong to a particular group, paren militia, close paren, when the other amendments clearly apply to everyone regardless of what group they belong to? Example, the First Amendment does not only apply to newspapers or churches.
Okay, the Second Amendment is textually unique. The Second Amendment is the only provision of the Bill of Rights with a purpose clause. Justice Scalia refers to a prefatory clause. In labeling the first part of the Second Amendment's text, a well-regulated militia being necessary to the security of a free state, a, quote, preface, Justice Scalia signals exactly where he's going, right? The preface, it's merely, the warm-up act. We get to the substantive right after we're done with the preface. Once you've seen the warm-up act, you can see the big show that you actually came to see. Of course, the text of the Second Amendment doesn't say, look, here comes the preface, you can snooze through this part, we'll get to the operative bit a little bit later on in the show. None of the other elements of the Bill of Rights come with a purpose clause. The only other purpose clause in the constitutional text relates to intellectual property. The copyright clause suggests that inventors will be encouraged to pursue their inventive arts if they have a monopoly of the proceeds from their inventions for a period of time. So the distinction that I draw between the Second Amendment and the other amendments emerges from the text. There is no other limiting, defining purpose clause associated with any other constitutional right enumerated in the Bill of Rights.
Do you want to comment on that, on that question?
I am reminded, and this is not a direct answer, it's an answer by indirection. I am reminded of what happens in the spring every year when I teach constitutional law. Invariably, I have a student who will come to me and say, the government should be allowed, the federal government should be allowed to do this, because what that does is ensure domestic tranquility, and in the preamble to the Constitution, we have this business about domestic tranquility. And I'm forced to respond that the preamble to the Constitution is nice, but it doesn't mean anything. It does not impart any power to the federal government whatsoever. I think that's the tack that Justice Scalia has taken. I'm not at all sure that he had to take that tack in order to come out with the result that he came out with. Again, I'm quite confident that this militia is the militia of the whole, and there are implications that come from that. But Justice Scalia cannot engage in the reasoning in which he engages unless he makes the conclusion that the prefatory clause is essentially without any limitation on the way that the operative clause is to be interpreted.
We have two questions that seem similar. I think we may have answered them already. I'm going to read them, and if either of you wants to say something about them, you should do so, but I think that we've already answered them. One is, by passing the Second and/or 14th Amendment, it's called bypassing, I think, the Second and/or 14th Amendment arguments, how would state preemption rules that apply to cities and counties apply to public entities like state universities? Do you want to say anything about that?
I suspect that's a matter of state constitutional law. That's a question of the relationship between the state and the local government and who takes prominence in regulation. I know in Louisiana, certain cities have very strong local charters such that the state government can't overrule or can't impose certain kinds of regulation. But I think that's idiosyncratic, and it's going to change from state to state and from state subdivision to state subdivision.
Do you have a comment about that?
Yeah, just to point out that there's a hierarchy of authorities. No municipality could opt out of a federal constitutional requirement because the state legislature authorizes it to opt out. So, right, whatever the Second Amendment means, and we now have an authoritative interpretation by the Supreme Court, once that right is applied against the states, municipalities and counties and state organizations will have to comply with the right as well. Very different question, on the state constitutional level. Many states have a more robust constitutional right to arms that is no longer linked to this sort of language about the militia we have in the Second Amendment. Many states have an older constitutional right to arms that sounds a lot like the Second Amendment. Other states have created a new constitutional provision that protects the right to arms or to weapons possession without reference to militia service. So, on the state level, that state level right would overcome municipal legislation.
Okay. This is for Professor Merkel. Why is there a distinction between average citizens and the militia? The militia are the people, the military is organized, but a militia is a group of armed citizens. If the right to bear arms was taken from the people it would also be taken from the militia. Do you agree with that?
It's quite a complex question. I'd have to, parse it carefully and ponder it in detail. I think one thing that the question drives at is the argument, and I think it's an argument that resonates with Professor Diamond, is look, the people and the militia are the same thing. Individuals comprise the militia. Whatever rights members of the militia had are rights that attach to the entire population. Yes and no. It depends on what the scope of the right is. If the scope of the right is to carry weapons for purposes of militia service, then the right exists only to the extent that the individual in question may be called upon to do militia service. You should probably know that what happened is that people got tired of the militia of the whole. In the 1820s and 1830s and 1840s, people stopped paying fines for non-attendance at militia muster. People started electing militia captains who promised never to make muster or just have a festival day or basically, a party whenever militia muster was scheduled. We got tired as a society of the requirement of mandatory militia duty. That's why we no longer have a militia of the whole. The people voted with their feet by walking away, and eventually states stopped trying to collect the tax. So in theory, we still have the militia of the whole. The federal United States Code labels all adults between 18 and 45 members of the unorganized militia. What does that mean? When was the last time you were fined for non-attendance, for militia duty, or non-possession of militia weapons?
We have two here about murder. I think that they're both about the same. Professor Merkel, you made much of the decrease in D.C. murder rates after gun banning in 1974. So since then, has D.C. become the most safe place to live in the U.S., or has the murder rate gone down all over the U.S., with and without repressive gun laws? And then another person said, you said murder has greatly decreased since the gun control measures. Why would a person who decided to commit murder be deterred by a law banning handguns? Can you respond briefly to both of those?
I don't think those are questions that are related to constitutional constraints on policymaking. Right? It may well be that banning guns is stupid policy, but the question before a court exercising judicial review as authorized by the Constitution is really only one. Does the Constitution permit or not permit the policy option that the municipality or state or the federal government has embraced? This is really none of a reviewing court's business, whether a particular policy is good or bad, unless, on rational basis review, the policy is so obviously stupid, so obviously irrational, that the legislature must really have been acting for improper purposes. Okay. Unless you can make the claim that D.C.'s gun laws were that irrational, then I don't see, where the court is authorized to intervene unless you embrace the originalist meaning that Justice Scalia embraced.
Here's somebody who disagrees with you, I guess, about an article in 2005 by Kovanjic, which you may have read, on homicide studies that examined the 15 studies that reanalyzed the data used in John Lott's 1997 story, or something on crime deterrence and the right to carry concealed weapons. Only 8 of the studies concluded that concealed carry reduced violent crime. I guess that goes to something that you were saying about local control.
Yeah, embrace whatever policy options the legislature wants to embrace. The question is, why is a court authorized or justified in saying you can't take this policy option?
D.C. could be wrong, but it's irrelevant.
Yeah, sure. There's plenty of constitutional laws that are that are
Shouldn't have
bad
been
policy, but are entirely permissible.
Okay. We're getting close to the end here. Here's one about Utah. If you're from Utah, you might want to be interested in this. All 9 of Utah's state universities, and then they include Colorado State University and Blue Ridge in Virginia, allow students the right to carry concealed weapons. Under what constitutional or legal basis does a state restrict a student's right? This is, again, along the lines of the questions that were asked before of you. A 21-year-old student is responsible enough to earn and spend a large sum of money, is required to get a gun permit and training, should be allowed to exercise their rights, I'm assuming on campus. In other words, shouldn't they be able to do that if they could do it elsewhere? This is one I think you've addressed before. Okay. Do you want to say any more about it?
Just one thing. I think it is not illegitimate for a state to allow the right to carry on a university campus to a 21-year-old who has a license. I think that that's a legitimate choice for the state to make. I might not agree with it, but it is legitimate. Steve Ambrose, who wrote the many World War II histories that he did and was a biographer of Kansas's own Dwight Eisenhower, Steve Ambrose makes the point that in World War II, what happened is that the 19-year-olds of the United States were fighting the 19-year-olds of the Germans, and that the 19-year-olds of the United States led, that we had lieutenants and ensigns who were in charge of people's lives and making great decisions, and we counted on them. We count on young people. We demand that they take responsibility. The choice that I would make personally, which is to ban guns on university campuses, is not the only rational or legitimate choice. And I will admit that.
Here's, we've got 2 left. Professor Merkel, it has been stated that rights... Oh, I'm sorry. Oh, well, so am I, so we understand each other, right? Okay. All right, let's see. What I like about these questions really is, rather than edit them out or not ask them, look how much effort was put into writing these questions, They really worked pretty hard on it. So I think they're entitled to an answer just as the way they wrote it. All right, it has been stated that rights come from the vote of the majority, and therefore Professor Merkel has said that the public ought to have the policy action available to them to restrict the right to defense or the right to a gun. But if the vote of the majority may take this right to arms away, then what is there to stop the abrogation of other rights?
Well, I don't think I said, and if I said, I misspoke, that rights are determined by majority preference. The question about rights is when they should be allowed to trump majority preference, in particular when judicial enforcement in the name of a right that the majority doesn't favor should be allowed to trump majoritarian preference, such as in the District of Columbia, where the government elected by the majority favored gun control, and one individual brought a lawsuit in the name of what was in the district an unpopular cause. So if we live in a completely majoritarian society, arguably like the society that existed in England, in the UK, up until certain, overtures in the direction of European-level constitutional review a few years ago, in which any act of the legislature is valid because it's an act of the legislature, then in a sense, we have no rights. We certainly don't have judicial enforcement of rights on a constitutional level. We have only statutory entitlements. We argue in the U.S. generally that the creation of constitutional rights reflects a supermajoritarian popular preference. If you think about how hard it is to amend the Constitution to create a new constitutional right, requires approval by 3/4 of the states and 2/3 of each house of the federal Congress. So ultimately approval by 88 of the 101 legislative chambers in the country. You're very hard to embody a new right by supermajoritarian democratic preference. Question of balancing, the desires of the moment with our long-term recognition of fundamental rights that at some point were so important they resonated with 80 or 90% of the people and achieved constitutional status by the amendment process.
Here's one for you, Bill, and it's a question I think that maybe many of them are thinking about. This person wants to know, is the Second Amendment impotent altogether? Does it have any relevance, I guess, is what they mean.
Well, obviously it's not impotent, right? The Supreme Court of the United States has signaled that it has great significance in the home, at least against federal incursion, and I think people in the Second Amendment game expect a decision very soon that it has at least some significance on the state level as well. So I think what the question really is if I had had my way and my vision of the Second Amendment had been recognized by the Supreme Court, if that swing voter Kennedy had gone the other way, would the Second Amendment be impotent? I think no. I still think it speaks to the right to hold weapons for militia service, but only for service in the lawfully established militia, to the extent that every state has opted into the United States Army National Guard scheme and provided for federal arming of the militia. Not entirely clear what scope the right would have in the here and now, but if any state opted to reestablish a militia of the sort we had before the United States Army National Guard, then I think the right could become very real. I think you can also make a sound textual argument, a sounder textual argument than Justice Scalia makes about the right of excluded groups to serve in the National Guard. If gays and lesbians are denied the right to service in the National Guard, what are they being denied? Well, the right to bear arms according to the received standard meaning of bearing arms as do military duty or perform militia service. Recall, that's the usage that occurred at least 95% of the time in the 18th century, not bearing arms to hunt a bear or bearing arms to shoot a home intruder, but bearing arms in the militia or the army. So if we have a right to bear arms in the militia or the army, if I was 85 years old and they said you can't make muster, I might have a claim. If I was gay and they said you can't make muster, I might have a claim. If I was 12.
Let's skip a few of those examples, but just let me ask you this. Your understanding, as I gather it from what you read, is that what the Second Amendment refers to is a right of a group, and that group was the militia group, which was the citizen group.
I say it refers to the right of individuals in the context of a group. In a sense, it's analogous to the right to jury service. You could sit on a jury by yourself.
Right.
If you're not in a court,
right.
What's the point?
Yeah, but my question is that group a specific group which no longer exists?
No, it's a group defined by statute, right, on the state level and on the federal level. But with the Dick Act in 1903 and the National Guard Act in 1908 and the Preparedness Act in 1916, every state basically accepted federal bribes to end its independent militia system and embrace membership in the National Guard system, which involves federal issuance of weapons rather than bringing privately held weapons to duty.
So you're under your vision of what they meant initially when they drafted this and enacted this, that situation no longer exists today? That the militia of the 18th century is no more, and what we have does not resemble it. Is that true?
That's part of my argument, but I don't think that means the right is entirely dissipated or ephemeral.
Dormant, would that be right?
I used that term 10 years ago. I now think that goes too far. It's not quite dormant. It was just
Semi-dormant? Okay.
severely limited by circumstances.
Next question, we're almost done. Judge, now you know how it feels, to be sitting here, right? Okay, but it's a lot of fun, I can tell you that. Here's another one. I guess you got a few people mad here. Let's see.
Yeah, you keep creating new questions. You keep
What do you mean
creating
creating? I'm
questions.
reading them. I'm trying to
Well, I guess the
get
good
rid of
people
them.
create the questions.
No, I think actually this is it. Now, all right, I'm going to stop there. Those are the few people whose questions weren't asked. I apologize to you for that because we have one last thing to do before we leave. Now, you know I've kept careful time here and that no one has ever gone over time. Are you right about that? We now have the closing statements. You, Professor Diamond, were the one who went first. What would you like to say as the last word you've got to this audience about these issues?
I've actually given a great deal of thought to that as we've been speaking. One of the things that I've written about is the place of the experience of black people in America with arms and the experience of arms on black people in America, and how that lens is that through which we can view the policy behind the right to bear arms and what I think the true meaning of the right to bear arms is. Let me share a personal story with you. In 1966, in my neighborhood in New Orleans, Louisiana, there was trouble. As they might have said in River City, which New Orleans is, lots of trouble. Someone was driving into our neighborhood and shooting at houses. I've actually been in the house of one of my neighbors whose then 2-year-old daughter had a shot about yay much above her head, and the bullet went into the wall. The people of this black neighborhood in New Orleans got together. There were men with guns. They hired security officers to help them patrol. And when in about 2 weeks, they found 2 young white teenagers from from St. Bernard Parish in Louisiana, driving into the neighborhood and shooting. These men who were patrolling the neighborhood with the security guard chased these 2 young teenagers literally into a police station. I think that that is a wonderful statement about how the right to bear arms can make our society safer. I know that we have an interest as a society, and I do not gainsay it, in minimizing the danger that attends from our being an armed society. But I think we owe ourselves more. We need to think about how to take advantage of the fact that we are armed and the fact that these arms are not going away. We need to be thinking about ways to enhance our security by building partnerships between the people and the police forces with whom we have such a love-hate relationship. How much time do I have, Mike?
30 seconds.
One other thing, I think we owe ourselves, at the risk of being self-congratulatory, a bit of applause. We have taken part here in what I've called the often acrimonious debate about the right to bear arms. No one has called anyone a liar. We have not raised our voices other than what was necessary to make a point or to give emphasis, and we have been respectful of one another. And I think that this is a model of civil behavior that we would do well to have more of in our country.
Another point of view. And now, Professor Merkel, would you care to close?
I have nothing further to say. except that I wish all of you who take roles in the policy-making process, whether it be as voters or legislators or participants in public affairs, the best of luck, courage, insight, wisdom as we collectively formulate public policy and try to address concerns related to violence and concerns related to danger. I think one of the great fears engendered by the Second Amendment debate is the fear in rural society that a bunch of ignorant do-gooders from the coast are coming to take away your guns. I don't think that that's a very real possibility, given the fact that those of you who favor gun rights enjoy a supermajority in the country. You were relatively safe against any self-styled army of do-gooders because they're in a fairly small minority. But by the same token, if the good people of San Francisco or Washington, D.C. opt to live under a relatively strict gun control regime, I think the people of rural America should allow them to undertake that experiment, even if that experiment is misguided or considered to be misguided.
Well, thank you. And that concludes our debate and questions. The cookies are outside, but one thing before we go. 1 o'clock tomorrow in this room, State v. Knight, I think we should show the judges that the interest in the Second Amendment is still strong here, and be interesting to see what kind of questions they ask and what kind of arguments are made in a real case involving this issue. So see you tomorrow at 1 o'clock. Yes, and we have one more comment.
Certainly want to take this opportunity to thank all of you who came out and participated. Certainly want to thank the committee member, Michael Kaye, for moderating. We want to give our sincere thanks to the judges who gave up their time to come out and participate. And last but certainly not least, we want to thank Professor Merkel and Professor Diamond for coming and being a part of us, and we want, as a part of the committee, give you a little token of our appreciation.
Thank you very much.
All right. Thank you.